Thanks for coming through. What, in essence, is the argument of those that do not want this practice to be banned?
Well, what Freedom of Religion South Africa is saying, that it takes away the rights of parents to decide what is best for their children. According to them, it is in the interest of the children for them to have the option to discipline them by use of reasonable chastisement, because not only is it in certain people's religion, they're saying that other people actually also believe that it is the best way to make sure that children do listen and are disciplined at the end of the day. So they're saying that it's basically the state interfering in how they bring up their children at the end of the day, and they're just saying that it shouldn't be the court that decides if a law should be changed. They're saying that should go to Parliament. The court had no right to seek clarification on that point specifically. They want to... What they're saying is, if it's not moderate and reasonable chastisement, there's already law in place for that. They're saying that it's assault if it's not moderate. But if there is a sort of leniency when it comes to parents being able to discipline, if they choose so with a physical then they should. Yes, but it depends, obviously, if it's moderate. But what is moderate? It depends also, according to them, about the age of the child. They're saying that they understand that, I don't know, if you're younger than a certain age, you can't, for example, hit a baby. And there's the other argument that if it's actually a teenager, then you'll get an aggressive response from that child. So everything comes into play about... You leave it in the hands of the parents to decide what is reasonable. And is that really a good way to go forward? Because some of the organizations raised the type of society that we find ourselves in, specifically in South Africa. They're saying that we are quite a violent society. Hitting your child or leaving it up to a parent to decide if hitting a child, to what extent or force is used, or what was the reason why they now deserve to be spanked. If you leave it up to the parents, you might get the case that we saw in the High Court, which was the initial case that brought up this matter. That was a father who was found guilty of common assault because he hit his 13-year-old son because he was watching pornography. What he was saying is he was just disciplining his son, but the court found that it exceeded the boundaries of what is reasonably acceptable, and that was common assault. But it's basically a grey area, and I think that became clear in court today.
Maybe before I get to my next question, let's just listen perhaps to what they had to say, Freedom of Religion South Africa, that is.
Just a one. Could I ask you, do you accept that if you slap a child, that is prima facie assault?
If you slap a child without the defense, right now, without that defense, it's debatable whether that's assault, because...
No, I'm asking you on the elements of the crime of assault. You've got... I'm not talking about the defense. If you slap a child, do you accept that is prima facie assault?
Prima facie, potentially an assault.
The same with if you slap another person, that is prima facie assault, is it not?
Well, it depends. If it was an intentional slapping of another person, while there may be some room to work around whether it was unlawful or not, it would be prima facie and potentially an assault.
Of course, I mean, what those opposed to what Freedom of Religion South Africa believes in have also been quick to point to research which shows that there are, in fact, disastrous physical, psychological, but also social consequences for the practice that Freedom of Religion South Africa is propagating.
And that was also brought up in court because the justices put it to the council, what do you then make of this, or do you accept it, or do you dispute this? What they're claiming is that all this research is based on the extreme violent cases. None of them are based in what they would call a loving family who in a loving manner wanted to discipline their child, and according to them, the best way to do that is with reasonable chastisement. So what they're saying is that they're disputing this, all these findings, because those are based on, for example, the case that we heard in the High Court, where it exceeded the boundaries of reasonable chastisement, and they're saying it was basically taken out of context and not looking at the close family unit that they say should allow a loving way of discipline, even if it includes spanking.
And the issue of the rights of children, was that explored any further or wider and deeply today?
Well, what they're saying is that the rights of a child comes above everything, above religion, above any cultural rights. And that is why even if freedom for religion, South Africa says, but they believe it would be in the best interest of the child to actually spank them, because they're going to learn a lesson that way. It didn't seem that the justices were really convinced by that argument, because the Constitution is really strong about the rights of the child, and that seems to be taking precedent if we really think that spanking a child is in line with what the Constitution says about a child's rights. And I think that's what the crucial decision that they will have to decide on.
Was the issue of alternatives to spanking explored at all?
Well, that's what they keep on saying, because they keep on pushing for this law to allow them to bring up this defense that reasonable spanking should be allowed. But what they're saying, that this judgment does not want to criminalize parents. What it wants to do is guide parents in a way to find alternative positive ways to discipline their children. And obviously that differs from parent to parent, some of the options that they use, but they said they believe that any use of spanking or corporal punishment, even though they didn't want to use that term because they said it's misleading, it should be a reasonable chastisement. They want to, sorry, I lost my train of thought there. They're saying that the positive alternatives should rather be explored than going straight to spanking.
When are we expecting a decision?
It might take some time, yes, we don't know. After the judgment was reserved, it will take some time, because this is crucial. This goes down to parenting skills, this goes down to children's rights and the future of the family unit, basically, in South Africa.
Okay, that's where we're going to leave it. Yanka Tolman, thanks very much for coming through. She was, of course, at court today, where the Constitutional Court was exploring this issue, the spanking of children.